the Constitution of the United States. It's an amazing thing, isn't it? It's an amazing thing to listen to some of these lawyers on these reprobate networks, MSNBC, CNN, or read the New York Times or the Washington Post, which I rarely do, but I do get clips, or the rest of it. And you can see how they target certain judges like Alito, Thomas, now Judge Cannon in Florida, and how they build up and praise others. This is an effort at obvious intimidation of constitutionalists, brainwashing of their very small audiences, while at the same time promoting activism on the courts because they don't believe in the Constitution. We've heard now for years about CRT. We've heard for years the 1619 Project. We've heard for years that the Constitution was written by white slaveholders, that this is a white-dominant society. But we're told today that the people who want to defend all this are the Democrats and Joe Biden. So at night, they're defending the Constitution. By the day, they're trashing the Constitution. What does that mean? It means they hate America. They truly do. They want to undermine America, and that's them, not us. So we have the Commerce Clause of the United States that has been eviscerated by the left. They're attacking the Electoral College as I speak. The power of the state legislatures to make election laws has been under attack and still is in courts throughout America. They've attacked the First Amendment, the Second Amendment, the Fourth, the Fifth, the Sixth, the Eighth, the 10th, and the 14th Amendments. Does it sound like they support democracy in America? No, I don't think so. I call the 25th Amendment now the dormant 25th Amendment because it applies to Joe Biden today. He has dementia, he's mentally unfit to stand trial, and he's certainly mentally unfit to be president of the United States. But of course, we're all faking it, and Joe is really the sharpest tack in the drawer. Now we have this appointment clause. And so the appointment clause is now center stage in the case in Florida, Fort Pierce, Florida, involving the documents case. Now, if you are foolish enough to listen to all the legal analysts on these other networks, you won't have the foggiest idea what's going on, because all they do is play politics. But this is about your Constitution. This is a very, very important issue that, again, goes to the issue of separation of powers. The Democrats only like separation of powers when they're out of office. When they're in office, they reject it. Why? Because in order to advance their American Marxist agenda, you have to destroy the barriers that are against it. And that's the Constitution. And that is their constant effort to attack, attack, attack while they dress themselves up as George Washington and claim they support democracy. Joe Biden has done this his entire life. He undermines, character assassinates, smears people who really do believe in law and order and a true justice system and our Constitution, while he's pushing the opposite, as I explained in some detail in last night's program. What is this appointments clause? Well, let's go to the constitution.congress.gov. What does Congress say? It's Article 2, Section 2, Clause 2 of your Constitution. It says in part, he, the president, shall nominate and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for and which shall be established by law. So you and I look at this constitutionally, say that's pretty clear. Well, the left, they're lawyers, they're justices, they're judges. They look at it and say, how do we get around this? You and I look at it, how do we uphold it? This is what it says. They say, how do we get around this? Now, they continue to say there, the deliberations at the Constitutional Convention in Philadelphia, major writings of the prominent supporters of ratification, and the words and records of the state ratifiers of the federal Constitution reveal careful consideration about the proper method of appointment for federal offices. The delegates to the Constitutional Convention, in designing a system of appointments for federal government offices, drew on their experiences with two flawed methods of appointment. First, the colonists who lived during the American Revolution resented the often unilateral power of the English crown and the royal governors, the colonies, to create and fill government offices. The manipulation of official appointments, generally achieved by creating and filling the key offices of government with political favorites, who were in turn dependent on the entity who appointed them, was one of the American revolutionary generation's greatest grievances against executive power, dictatorship. Second, many early state constitutions adopted after the Declaration of Independence was written
reacted to the perceived abuses of appointment power by the Crown and royal governors by lodging the power to appoint officials with the state legislatures alone. So here you had centralized, here you had completely localized. But placing the appointment power with the state representative assemblies caused considerable turmoil. Those legislatures were seen as consolidating all government power, executive, judicial, and legislative, for themselves. Remember, you need power checking power. That is the heart of our system, separation of powers. This consolidation of power had become the principal source of division and faction in the states. So their point is this: the concentration of power in the hands of few, or the concentration of power in the hands of a legislature, it's still tyranny. It's still tyranny. At least in the views of many delegates to the Constitutional Convention, the failure to give governors a stronger role in the appointment process was damaging to many state governments whose legislatures had fallen easy prey to demagogues, provincialism, and factions in their exercise of appointments. Likewise, the Articles of Confederation, which provided the governing framework for the young republic before the adoption of the federal Constitution, authorized the Continental Congress to appoint officers. So what did they do? The delegates to the Constitutional Convention at Philadelphia were aware of the weaknesses of these models of appointment, both of them, and thus chose instead to separate the power to create federal offices from the power to fill them. They chose to vest Congress and the legislative power, including the authority to create federal offices, while the power to appoint the most important officers were placed with a single person, the president, subject to confirmation by the Senate. Separating the power to create offices from the authority to appoint officers would, in the words of James Madison, provide one of the best securities against the creation of unnecessary officers or tyrannical powers. So what do we have here with the special counsel appointment? First of all, you should know that two former attorneys general, Ed Meese under Reagan, Michael Mukasey under Bush, have filed two briefs, one in the Supreme Court in the immunity case, the opinion of which will probably be released at the end of next week, and in the case ongoing in Florida, directly in the Appointments Clause, they have filed a brief arguing that the appointment of Jack Smith as special counsel is utterly unconstitutional. These are two former attorneys general. Now, this is a very serious matter. You really need to not listen to the munchkins, the legal munchkins, the grifters, the slip and fall lawyers who are dressed up as some kind of experts on these other networks. So the position established by the Constitution or a statute, the position is to be created by the Constitution or a statute, or a statute giving the authority to a principal officer to delegate power. That's what the Constitution says. Okay, was Jack Smith appointed under the Appointments Clause part that deals with confirmation? No, his name was never sent to the Senate, so the Senate didn't get to participate in his appointment. Is there a federal statute that authorizes the Attorney General to make such appointments, inferior officers, to delegate that power? Not one. So there's no constitutional or statutory authority for Jack Smith's appointment. Now, Congress has, in fact, conferred this power by statute on the Departments of Transportation, Agriculture, Education, and HHS to appoint inferior officers, but not the Department of Justice and the Attorney General. Now, is this so-called special counsel a principal or inferior officer? If he's principal, the Senate must confirm the appointment. He's the most powerful prosecutor in the United States. The other U.S. Attorney federal prosecutors are all called principal officers. Every one of them had to be confirmed by the Senate of the United States. By every definition and by his enormous power, beyond that of any U.S. attorney, all of whom require Senate confirmation, Jack Smith has the power of a principal officer, not an inferior officer. To comply with the Constitution, all the Attorney General had to do was appoint, for an example, a current U.S. attorney who was already confirmed by the United States Senate. But he didn't do that. The Attorney General can't gut the Appointments Clause, the critical role of the Senate, and appoint whomever he wants off the street without any constitutional legal authority, and that's what Ed Meese and Michael Mukasey, two former attorneys general, are saying. Now, also, Attorney General Barr, most recent example, he appointed David Weiss, special counsel in the Hunter Biden case, the U.S. attorney for Delaware. So he complied with the Constitution and statutory authority. He also appointed John Durham special counsel, who was also a sitting U.S. attorney in Connecticut, to conduct his investigation. Garland chose to violate the Constitution. He has no statutory authority, and he reached into The Hague to pick somebody he wanted, a hitman, Jack Smith. But for our purposes, Jack Smith isn't a principal officer. He's not even an inferior officer. He's a nothing. Let me give you another example. In 1978, Congress passed the Independent Counsel Act. It was called the Ethics in Government Act, but it created an independent counsel. It allowed the appointment of a special counsel by a special three-judge panel. I know, I lived through this. I was Chief of Staff to Attorney General Meese when independent counsel were being appointed left and right. The law had a sunset provision every 5 years. It was not renewed, and it expired in 1999. Both the Republicans and the Democrats said, enough of these independent counsel. They're doing damage. They're responsible to nobody. But they didn't then pass a statute to create the power within the Department of Justice for the Attorney General to appoint a special counsel. A regulation was issued by the Department of Justice giving itself power to appoint a special counsel. Well, that doesn't fly, does it? Remember the beginning. Congress wanted checks and balances, separation of powers, power versus power. The president can appoint, but the Senate gets to have a say. An attorney general can appoint, but he can't appoint somebody like Jack Smith. The Department of Justice does not have independent power to issue a regulation for appointing a special counsel in violation of the Constitution and without any statutory authority whatsoever. This is the matter that is before Judge Cannon. She's being threatened and intimidated by the media. They are trashing her. You could see the reports from CNN 2 days before the Friday argument, the day before the Friday argument, on the Friday argument the other day. The same thing with the New York Times, the same thing at MSNBC and CNN. They're trying to persuade you that she's a lightweight, that she's really out of her league, that other judges feel this way, that she's slow-walking these cases, that she's a Trump appointee. Well, guess what? Every federal judge is a somebody appointee. What, would they prefer, a Biden appointee? Of course. Would they prefer an Obama appointee? They never say about Chutkan in Washington, who's a horrendous judge, oh, she's an Obama appointee, or the two horrendous judges on the panel in the circuit court in D.C. Oh, those are two Biden judges. They don't say that, do they? She's to be measured by what she's doing. And what she's doing is exactly the right way for a judge to conduct him or herself. These are unique constitutional issues that are being raised by an unconstitutional, ironically enough, special counsel. Whether it's immunity, whether it's obstruction under the Enron law, whether it is whether his appointment per se is constitutional. These are all issues being raised by the Biden administration, the Justice Department, and Jack Smith that have to be addressed. But they want her to hurry. They want to get this done. They want her to steamroll all these issues. But she's not. She's actually doing what a judge many years more senior than her, with great deal more experience, would be doing. Actually trying to apply the constitutional law to the events that are taking place. One other thing I just want to emphasize. Meese and Mukasey, the two former attorneys general, take this so seriously that they've raised it in the Supreme Court in the immunity case. And they raised it again in the Florida court in the documents case. And the judge can rule one of three ways in Florida. Number one, she can ignore the Constitution. She can ignore the fact that there's no statute, which would truly just undermine another part of the Constitution and separation of powers as they steamroll their way, the Democrats and the left and the Biden administration, into this Stalinist-type star chamber. Or she can rule, and should, that the appointment of Jack Smith is unconstitutional, and therefore everything he has done is null and void. Or, secondarily, I support that conclusion, she could argue that the appointment of Jack Smith is unconstitutional and give the Department of Justice 30 days or so forth to hand the case over to a constitutional appointee like a U.S. attorney. I am less excited about that position. But she could do that. And full disclosure, Landmark Legal Foundation, of which I am chairman, has filed one of those briefs and made one of the arguments on Friday that Smith is an unconstitutional prosecutor. So this is a very serious matter, and depending on how the ruling is made, it could have an enormous effect on yet another part of the Constitution and separation of powers that Mr. Democracy, Biden, and his hack attorney general don't give a damn about.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.